Mr. Lukiszki, 4 minutes, please.
Thank you very much. I just want to ask a question. My understanding under the amendments of Part 4 of the Telecommunications Act, there's a distinction between what's considered to be a violation and an offense, and there are monetary penalties attached to both. On a violation, which is the lighter of the two, my understanding is the penalties could range anywhere from $1,500 to $15,000. However, if it's considered to be an offense, which I assume something like the Pierre Poutine situation would be, monetary penalties are in the range of $10,000 to $250,000. So my questions are, could you give me some illustrations or examples of the difference between what would be considered to be an offense as opposed to a violation, and is there precision in the language in the Telecommunications Act that would clearly define the difference between the two, or is this a bit of a judgment call? And if so, who makes that judgment call to determine if it is only say, an administrative violation or a more serious offense? I'm a little confused about how one will actually determine the severity of the transgression.
We could undertake to provide that information to the chairman within that same timeline, if that's acceptable.
Can you give me just some quick example, top of mind, that might be considered to be a violation or has been proven to be a violation in the past, as opposed to what might be considered to be an offense?
Making ADAD calls, robocalls outside the timeframes that are specified in the unsolicited telecommunication rules would be a violation that we would levy an administrative monetary penalty, and in the case of individuals, the penalty can be up to a maximum of $1,500 per day per violation, and in the case of corporations, $15,000 is the maximum per day per violation. Another example would be failing to identify on whose behalf the call is being made. Another example would be failing to provide a phone number or displaying the number from where the call has originated. Those are all the kinds of violations for ADADs that we administer under the regime of the do not call and our unsolicited telecommunication rules, and those would attract the penalties that I've just mentioned. Okay, the reason I'm asking, I'm just trying to get clarification. The only, to my knowledge, and correct me if I'm wrong, the only transgression that has been noted by the CRTC and fined accordingly was our colleague in Parliament, Mr. Valeriot in Guelph. And his campaign during the last election had made a number of calls in which the caller did not identify herself, did not identify the fact that the call was coming from the Liberal campaign. He was found in violation and fined $5,000. Who made that decision? Who made that decision that it was only a violation and not an offense? Because to me, I'm sorry, and obviously I'll be accused of being a little partisan here, but it's quite apparent that that call was made deliberately to mislead the recipients of the call in an attempt to influence voter outcome. That's pretty serious stuff in my opinion, so I'd just like to know exactly who made the decision that this should be a reduced monetary penalty as opposed to a more serious offense. Under the Telecommunications Act, under the regime, it is the Commission that makes decisions as to the amount of penalty, and my colleague, the Chief Compliance and Enforcement Officer, would be conducting the investigation into the complaints as she's indicated. All right.
It's a good shot. We're going to try a third round at about 2 minutes each, so Mr. Lukiszki, if you'd like to go on, you've got 2 minutes.
Thanks very much. I'd just like to be, I'd like to follow up on that latest round of questioning. Do the decisions that you make in relation to how much a fine might be, or the transgression itself, the severity of the fine, are those decisions made public?
Once a notice of violation has been issued and it includes an AMP, whether it includes it or not, it becomes public. But there's a period of time where the regulated party can make verbal written representation to the Commission if they want to bring us to our attention facts that could change some facts around the case. So
Yeah,
there's a 30-day period for representation, and then the decision becomes public if it stands.
Yeah, I'm more curious about the decision-making process and how the Commission determined that in Mr. Valeria's case, it was a minor violation worthy of a $5,000 fine as opposed to a more serious offense for voter suppression, which we obviously all agree that the Pierre Poutine incident was. So that's my earlier question. Is this a judgment call, or is there a precision in the language in the Act that gives you guidance?
There's a telecommunications decision that was issued by the CRTC in 2007 that lists the factors that are considered in the making of that decision. But there is discretion, of course, in the officer's judgment with regards to what constitute a significant violation, for instance. But the factors are listed in the decision without removing the flexibility and the judgment of the officer, given the circumstances of the case.
So if I'm hearing correctly, the final determinant is a judgment call by whoever the official was who's conducting the investigation, guided by a lot of the factors that you've already articulated. But at the end of the day, someone's got to make a call whether or not this is a minor or a serious transgression.
Quick answer to that, if
Factors that are taken into consideration by the Commission in making decisions are listed in their policy 2007-48, and every case is considered under its own facts, and the parties that have been brought before under notice of violation can make representations within 30 days, and those are considered by the Commission, and the Commission makes the decision then.
all right, thank you very much. Madam Latz-Andress, 2 minutes, please.
Merci, monsieur.
Thank you, Mr. Chairman. I will continue with questions that my colleague asked in the first round. Could you confirm that the registry will contain the numbers called as well as the scripts will not contain? And for the information that will be held in this registry?
Contain the information that's required in Bill C-23, and that information would be the name of the calling service provider, the name of the group or person on whose behalf the services are made, and it will not contain the phone numbers. But at the time that the registration notice is filed, there's an obligation on both the calling service provider and the person who entered into an agreement, person or group who entered into an agreement with the calling service provider, to provide the CRTC with their name, their address, and their telephone number, and a copy of the identification that the CRTC has authorized them to use. So you get the registration notice to the CRTC and that information that I've just explained to you, and the script and recordings are required to be kept for a period of 1 year. And the purpose of that is if there's an investigation, the CRTC may request those, but they don't form part of the registration notice.
But the one, la période d'un an, c'est pour les compagnies.
1 year period is for the companies. Does the CRTC, there is no limit to the time that the CRTC is required to keep this information? As a government agency, we keep our files for a prescribed period, and I believe the period is 7 years, and that's a minimum. Thank you.
On and hopefully finalize the last thoughts on the line of questioning I've been pursuing. There have been, from time to time, many candidates from different political parties who have been fined by the CRTC for various transgressions, going back to, again, the judgment call. Do you think it would be helpful to have a tighter set of determinants for the CRTC when examining cases where there have been violations? Or are you satisfied with the definitions that are provided to you in its current state are sufficient? In other words, would you like to see a little bit more guidance, or are you satisfied that what you have now ultimately will lead to proper decision-making?
We think the provisions of the proposed legislation are very good provisions that will certainly give us an ability to investigate the violations under this piece of legislation, which would be the failure to register notices. And other than that, you know, our role is to implement the policy that the government puts into place through its legislation, and we're you know, very happy to do so.
So you have then no other suggestions for improvements that, from your perspective, that you could offer this committee?
Well, the current regime that it's under, the unsolicited telecommunications rules with regards to the penalties, would apply, and so far it's been working very fine for us.
Okay. Thank you.
I think work with the legislation. If it's passed, then we'll see how it works.
Great. Thank you very much. I'd like to thank our witnesses for coming today and sharing with us views from the CRTC, and we thank you for doing that. Members, we will suspend. We're back in this room tonight at 7 o'clock. Pardon me? I'm adjourning because it'll be a new meeting tonight. I'm not suspending. Very good. We are adjourned.